I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your man TP. Today we're jumping into number 82 on our compilation list, and we're going to be in 4 different courtrooms on today. There will be no commentary at the end of this compilation. As always, I will be adding chapters for your convenience. Don't forget, guys, to like, share, comment, and subscribe. It is always appreciated. Now, let me give you the rundown of these judges' courtrooms that we will be in for number 82. First, we will be in Dane County Courthouse in the state of Wisconsin. Second, we will be in the courtroom of Judge Sean Perkins out of the state of Michigan. Third, we will be in the courtroom of Judge Tammi Hayward out of the state of Georgia. And last but not least, we will be in the courtroom of Judge Erane, Washington, out of the state of Michigan. Guys, we are heading to number 100. We are running through these compilations fast. It's so much content that we've shared here on the channel, so many different proceedings to put together, many that a lot of you haven't seen, especially you guys that are new to the channel. So I'm excited to bring you to those. But with that being said, let's go ahead, guys, and jump into number 82.
I have to assistant counsel.
I'm sorry, who we have here? This is Mr. Griffen.
Anthony. I'm not administrator. I asked for assistant counsel, not counsel.
That's right. We'll go on the record in the state of Wisconsin versus Anthony Griffen Jr., case number 25 CF 939. Could you get the appearances, please?
Assistant District Attorney Jack Schneider for the state of Wisconsin.
And you're Mr. Griffen, is that correct?
No, all statements for the record comes now the living man, Anthony of the Griffen family.
All right, so Mr. Griffen,
appearing expressly.
wait, you need to stop talking. Is Mr. Griffen
appearing expressly
hearing today? Are you Mr. Griffen or not?
I am Anthony of the Griffen family.
Are you the Anthony Griffen
the
that is charged?
estate
Stop a second here.
You asked me a question, I'm answering it.
Okay, I don't want you to answer it anymore. I want a yes or no answer to a question, okay? And the question is, and I have to get the case back in front of me, I'm sorry, but bear with me. Lost my calendar. I have a simple question for you.
25 CF 939.
Are you Anthony Griffen with a date of birth of August 20th, 1985?
I am not the dead entity Anthony Griffen. I am the executor of the estate. I do not agree to be.
All right, well, we'll have to set this over and hold you in custody then until we can have a later.
I will check, as I've been held for 72 hours without seeing the judge. That is unlawful.
But you're not Anthony
So
Griffen.
you are agreeing to violate my common law rights. Is that what you're saying?
I'm asking you to, let's do this, okay. I'm gonna find probable cause that this is Mr. Griffen, that is acting in an obstructing way, but we'll go ahead with it. Do you have a copy of the complaint there in front of
I
you?
object that you're obstructing my justice.
Your objection is noted.
I'm a Moor. You have.
If you keep talking over me, we're gonna cancel
You're
this.
talking over me. I just want to state the facts. Do you not want the facts to be stated on the case? Am I not allowed?
You're not allowed, no, you're not allowed to talk about it.
Of attorney. I am not.
Okay, let's hold him in custody. We're canceling this hearing. You're gonna have to be
That's
held.
okay.
You're not willing to cooperate. Make a record.
Show that you're violating my rights. Let the
Record note that he refused to cooperate so that an initial hearing could be conducted. That's 25 CF 939 appearances.
88 Sister Marco for the state.
Understand where the Vice Defendant's office defers to Mr. Griffen has indicated that he wants to take care of his own case. Right?
Is that right, Mr. Griffen?
I'm not Mr. Griffen, I'm Anthony of the Griffen. I have the power of attorney for him. I do not have a question for the court. Will I be allowed to speak freely or will my civil rights be again granted over?
Oh, you get to make a statement on bail, but we're going to do this in an orderly fashion. But you're indicating that you're not Mr. Griffen, or that's just not how you identify yourself.
It's not about me identifying myself and be very carries my all caps entity with the dead entity. I actually have an EIN for this created entity. This is not me. I also do not live this address. I'm also not a black man. I am on board. So a lot of things on here are totally wrong, which not be at all. My weight is not 240 pounds. All this information is false. As for the record, all savings for the record comes now the living man and the other Griffen family, ensuring there is appropriate persona status, appearing expressly to continue the record arrest accordingly. I'm not to be mistaken with the all caps estate, as I am the occupant of the executor office and also the sole beneficiary of the state. I filed my power of attorney with the court and I'm ready to proceed. Let the record show that I do not agree to be a surety for the dead entity as it was created from the state and was given to me and is not a representation of me. I am not one who owes debt to the United States or to the state of Wisconsin. Further, I'm not a flight risk. The only reason I missed court was due to the failure of the court to notify me of said date. Furthermore, upon being detained, I made it very clear to Officer Gilson that I wanted my rights read to me. Officer Gilson first refused after we asked him twice more than he read me my rights. After Officer Gilson read me my rights, I made it very clear to him that I wanted my attorney present with the sheriff. Officer Gilson then replied, "They won't come." I made it very clear to him that if he continued to talk to me without my attorney present and the sheriff present, it would be a violation of my civil rights and my constitutional rights. He ignored these facts and continued with the arrest in violation of my law and the rights and the protocol that he agreed to follow as an officer. I was pulled over while traveling in a private automobile. The plates read, DOT exempt, do not detain private traveler. I made it very clear to him that he does not have jurisdiction, but yet he forced it. I was never properly identified as a suspect. My fingerprints were taken under direct arrest of origin after I told them I did not want my fingerprints or paper taken until I have a court order from the judge. I do not argue with any of the facts in this charge against me. This is not me taking a plea. It's accepted for value and returned for value. All the charges continues in this case and use my exemption for discharge and set off and release the order to me immediately.
Okay. Well, I think there's at least a reasonable inference on the record that the person known as Anthony Griffen is the same individual in front of me. When they call Anthony Griffin's case, he came out of the holding cell. I don't know why he would do that if he's not. I gave you an opportunity to speak. I'm speaking now, sir. You can object. There's no basis for it. I'm looking at the court records. Please don't interrupt. I'm looking at the jail records.
The Trust Act of 1666 says that when somebody claims their estate, you are to relinquish all of the things to them.
I don't know what you're talking about.
That's
I've never
okay.
heard that ever.
That also means that this
You
is not
can file your written motions,
not a
Mr. Griffen.
competent court with jurisdiction, and I challenge jurisdiction under Federal Rule of Procedure 5.1.
It's denied. The booking photo and the filming records match this particular individual. I'll find probable cause.
Man can be lord over his own case.
And where would you like us to send mail, sir?
You already have mail. I told you on file. It's P.O. Box, the Forest, Wisconsin,
Okay,
53532.
thank you.
And I have a right to be on all recognizance.
What's the state's position on bail?
Thank you, Your Honor. In this case, the state is asking the court to impose $1,000 cash bail with the condition that the defendant be prohibited from possessing any dangerous weapons as defined by the respective statutes. It's my understanding that the defendant posted $5,000 cash on his current pending felony case and then failed to appear in court. He is alleged to have refused to identify himself and has committed additional crimes while out on cash bail, which is, as we know, a general violation of bond conditions.
I object.
It's our position that
Let her finish. We can't have this hearing. We are talking over people. We're trying to record it. What's the basis for the
The
objection?
basis for the objection is the fact that she has no basis of knowing who I am. I don't know who she is.
All right.
She's not even.
The objection's overruled. I ruled it, Mr. Griffen. Let her finish.
As far as that failure to appear, Your Honor, it looks like a bench warrant for a body only hold was issued on January 27th of this year in pending case 24 CF 907. That warrant was not served until almost 3 months later on the 17th of April this year.
So Your Honor, they're sure or not that when somebody has a court date that they have to be served the court date so they know that it's there. Or is it okay to actually set a court date without notifying the defendant or the accused and then locking them up for one?
All right, and I gather you're alleging that Judge Highland did not send notice to you?
No, there's no certified anything there. There's no document or proof of service of anything of that date. I went to every previous court date and I don't skip court date. He didn't show up for the last 3 court dates prior to that. And I actually put in a motion for failure to prosecute, yet they still moved forward as if nothing was placed in and no one came to court except for me and the prosecutor, and the judge was, I don't know, hiding in the back or whatever the case may be. I filed an abatement just to let them know I'm not the person who they are looking for, but yet I keep getting trampled over in court. My rights keep trampled over in court. You have this person standing to the left of me who knows me not at all, and yet I would like her to take the stand and talk about how she knows me personally, because you cannot be a beneficiary.
Well, we're not going to be
She's
doing any of that,
as the
Mr.
state,
Griffin.
and she is not the state. I know her not. I don't understand what's going on.
All right, well, it looks like they mailed notice to the address that you had on file at the time.
So
But you're gonna have to take that up with Judge Highland. That case is not before me. Looks like he's issued a body only warrant. You can't get released on that until you have a hearing with Judge Highland in that case. I think given the history, $1,000 cash bail is necessary. I will set that.
I object, and it's clear that
And that's
your
fine.
rights have been violated, and you're still moving forward. This is called an obstruction of justice.
Don't
Let
think
the
that
record
your
show
rights have
that.
been
Know
violated.
everything that I've said.
It's all being recorded, Mr.
Doesn't
Griffin.
matter.
You would have the right to a preliminary hearing in 10 days. Do you want that scheduled?
But I don't want to sit in jail any longer.
Okay, well, you're gonna have to get a hearing in front of Judge Highland on the other case. Right now, you're not allowed to post any cash bail to get released in that particular case. I don't have any authority to do anything with that.
So if you don't have authority, that means
You're
you don't
gonna
have
have
authority over me.
to address
I object.
that
If you don't
case
have
with him.
authority to actually set me a bail, you do not have authority over me. Matter of fact, Your Honor, are you responsible for me if something happens to me?
All right, and I'll also order that you not use or possess dangerous weapons as it's defined by the state
Are you
statute.
responsible for
And because I haven't heard a response, I don't believe we have a waiver of time limits to set a time
Are you
preliminary
responsible
hearing.
for me if something happens?
And we are adjourned. Mr.
Okay,
Griffin.
since you're not responsible for me if something happens to me, let the record show that you are not. You are crazy. Bad for the city, never us.
Mr. Little, what do you want to do? Trial or take the deal?
What I want to do, I want to get it dismissed.
It's not gonna happen like that. You know it's not gonna happen like that. You
But
got
that's
to
okay
dismiss
too.
last time.
I would like to make it a matter of record, because I want to, prove that the court does not have the jurisdiction to even prosecute.
All right, I'm gonna get the reviews out.
Okay,
and then I'm
they
gonna
could
call.
be fraud.
All right, hold that, I'll just make a record.
Point all this stuff out.
I'm gonna get the reviews out and then I'm
Yes,
gonna let,
Yes,
you
sir.
make your record and we'll get you on.
I also like to see those, bonds today too, sir.
I don't know what you're talking
You
about.
know, they sitting on your desk, they sitting on her desk, no file over there.
All right,
Take a bond every time the person comes to court. Financial, has nothing to do with it.
all right, City of Detroit, Mr. Hardy, now, I'm gonna give you a chance now. Let's not keep going back and forth. Wait till your turn gets ready. City of Detroit. Versus, Brandon, let's start that, Bernard Brandon Little, case numbers SP 1695294, counts 1, 2, and 3, SP 1695296, counts 1 and counts 2. Mr. Little, good morning to you. State your name for the record, please.
Grand Right. First of all, Your Honor, I'm your magistrate. I would like to know, do you recognize that a man sample for you?
Stand up, stand up to the
I'm at the
podium.
podium right here.
No, stand up to the podium.
Your Honor.
All right.
No,
we're not gonna do this your
I'm
way.
standing at your podium because under duress, I'm standing at your
We're
podium.
gonna do this my way.
Yes, sir. We are
All
gonna
right.
get your way.
All right. State your name for the record again, please.
For matter of record, Your Honor, do you recognize that a man standing before you?
I do.
All right. For the record, my name is Bernard Brandon Little. Nothing fictional, nothing all caps, but man.
Okay. Now, anything that you wanted to make a record, I was allowing you to make that record. You indicated some things in the record.
I indicated on the record that you stated that I was a man. A live man, not fictional.
No, we off the record when you were.
No, we're on the record,
Listen,
Your
listen.
Honor. Did you recognize that a man standing before you? Your Honor,
Listen, sir.
your magistrate.
Mr. Little.
I'm asking you.
Mr. Little,
Yes.
you don't ask the questions, I ask the questions.
No, you don't, Your Honor. No, you don't.
All right.
You're a magistrate.
All right, listen.
You don't have the authority. You
That's
don't have
it.
the authority, Your Honor. You're a
Listen,
magistrate.
listen,
You don't
sir,
have the
I'm not gonna
authority.
keep going back and forth with
You're
you.
not going back and forth with me.
Put him out.
Yeah, put his ass up.
And don't, I don't need your comment either. Whoever made the comment. All right,
So
get out.
you're refusing me?
Get out.
You're refusing me, Your Honor?
Get him out.
I need to ask you something.
Yes, ma'am.
No problem. I got you. Okay. Have a good day, Mr. Love. While court is in session, everybody needs to have their device on vibrate or silent.
All right, DeMarcus Cantrell Brown.
We are going to be submitting a withdrawal to you. You should have it shortly.
All right, Mr. Brown, are you represented by somebody else?
Yeah, for the record, I am DeMarcus Bay, the implied surety for DeMarcus Cantrell Brown. And I would like to file a motion in the court for additional 30 days for me to seek counsel.
Okay, so Mr. Bay,
Yes.
AKA Marcus Cantrell Brown, so you're seeking a continuance to get new counsel?
Yes,
Okay, do you have someone in mind, sir?
I not right now. I'm seeking counsel.
Okay, so here's the thing. I'm going to give you a continuance for 30 days, or I'm sorry, until January 5th. But by that time, you need to have counsel on board when they come back so that they can talk to the state to determine if there's anything that they can work out on your case, or if they need to get all of the information necessary for a trial, if that's what you choose to do. So by January 5th, I will expect that you will have counsel.
Well, I have paperwork on the docket that haven't been rebutted. I have affidavits of truth that haven't been rebutted.
Okay, sir, we don't do affidavits. People have to appear in person because there's a confrontation clause in the United States Constitution that says witnesses, you have the right to confront witnesses in person. So we don't do affidavits, okay? If you have witnesses that are going to present testimony or evidence on your behalf, then you have to have them come to court and be sworn in and testify at that time, okay? So we're not doing any dismissing and all of that stuff. No, sir. When you get your counsel, they'll be able to discuss it with the state, and then y'all can present whatever to the court.
And the accusing deputy must be present too, right? Okay.
So the people always say that, but here's the thing. The state gets to choose whatever witnesses they wish to bring, just like your side gets to choose whatever witnesses you wish to bring. You can't rely on them to bring the person that you want. So if you want to subpoena someone to appear for trial, then you need to subpoena them. You cannot rely on the state to bring your witness. Okay.
Okay. I got you.
All right. Anything else?
And jurisdiction can be challenged at any time, right?
No, sir. Jurisdiction rests with this court because this is where the locus of the incident is.
Well,
Mr. Bay, let me just explain something to you. Mr. Bay, listen to me.
Okay.
I went to school for 3 years for this. That's full time. If I had gone part time, it would have been 4 or 5 years. And I have been working since, oh Lord, I ain't gonna give my age, but I've been a lawyer and a judge for quite some time. I've been a judge for 10 years as of this year. A lot of times people come before me because they've learned stuff from other people, or they've gone online, or they've read it themselves. But I tell you, it doesn't work the way you think it works. And so there's a set of statutes, cases, procedures, all of those things that we have to learn. In fact, let me show you something.
Well, how do you have?
Wait. You see this book right here? This is just this year's edition of all the stuff that I have to be able to find to figure out what's going on in your case. This is just this year's edition. And I got a book like this that includes evidence and procedure. I got a whole wall of books. So when you come in here challenging jurisdiction and all of this stuff people have taught you, it's not books.
Can I show you my Black Law Dictionary?
No, sir. Because Black's Law, that's a dictionary. That's not the full case. You know, you come in with all of these ideas about how you think the law works, but every lawyer in here has done at least 3 years of law school and trainings, trials, all of those things. So you're not going to change the way we do things. So the best thing to do is to get an attorney who can talk to the state about your case, and then we can get this resolved. Your case is pretty simple. You got traffic offenses.
Well, I still want you to prove on the record that you have subject matter jurisdiction, personal jurisdiction.
I'm not proving anything on the record, sir. I wear the robe. They put me in this position. I've been here 10 years. If I didn't have subject matter jurisdiction, I wouldn't be here.
So it's not a difference between public and private for the record. There's no difference.
Sir, get an attorney.
Okay, all right. January 5th.
Yes, sir.
Okay.
And Mr. Bay / Brown, you've indicated that you wish to have an attorney, so I'm going to rely on the fact that you're going to have an attorney. Don't come back here with the same stuff, and I already told you it's not going to work.
So you're telling me United States codes don't work?
No, I'm telling you, you don't know them. So first of all, right here. The United States codes don't work in Georgia because Georgia has its own code, OCGA.
So the meaning of driver is different in Georgia.
Yes, sir.
But according to 49.
Mr. Bay, I'm not doing this with you. Get an attorney.
Okay.
Thank you, sir. You're free to go. We'll see you on January 5th at 11 a.m. So DeMarcus Contrell Brown.
I have interest in that matter. Is the defendant in error free to go?
If the who, what?
Is the defendant in error free to go?
No.
Well, let the record show the defendant in error is ordered to stay and participate.
Okay, who is the defendant in error? That's a new one for me.
The all cap name is trust that I am a beneficiary of. My name is not spelled in all capital letters. I have a court order decree saying that.
Okay, Mr. Bay. Mr. Bay, do you have an attorney representing you, sir?
Attorney General, my Attorney General is online. You may speak to me, sir.
Is the Attorney General, Mr. Bay, hold on. Let me ask my question before you tell me something crazy. Is the Attorney General a member of the State Bar of Georgia?
I'm a non-state actor. I'm a foreign national. Matter of fact, I filed
Mr. Bay. Mr. Bay, I don't care if you were Alexander Putin, the premier of Russia. If you are in Georgia and you're represented by an attorney, that attorney would have to be a member of the State Bar of Georgia. Foreign national or not. Just as if you went to another country and you had an attorney represent you, that attorney would have to meet the requirements of that country and of that state. Okay, Mr. Attorney, Mr. Bay, hush. Mr. Attorney General.
I'm trying to set a record.
Mr. Bay, Mr. Attorney General, are you a member of the State Bar of Georgia? You want to unmute for me?
Speak, bro. Get off me.
What's going on is he's a member of a foreign state corporation basically doing business in Georgia. So
okay,
basically,
sir, that's not what I asked you.
No, sir. I get what you're saying, man.
No, and I get what you're saying, but we're not doing that because that's not how we operate. Those are not the laws under which I am required to conduct court. So we either gonna do it my way or we're gonna put you on the calendar.
We understand the rules of the court. I got you.
Okay. Are you a member of the State Bar of Georgia?
No, I'm not a member of the Bar of Georgia.
Okay,
what I'm trying to realize
he can represent himself.
You need to take consideration on that matter on how he's doing business in Georgia.
He can represent himself, or he can be represented by a member of the State Bar of Georgia. But he cannot have you represent him or purport to represent him. Okay, that's not going to work. All right. So, Mr. Bay, do you wish to choose someone who is a member of the State Bar of Georgia to represent you, or do you wish to represent yourself?
I invoke my right to remain silent as the beneficiary of Demarcus Cottrell Brown estate.
Okay, sir. So, sir, you're invoking your right to remain silent, which means that you do not wish to enter a plea that
I plead to be released.
That would resolve your case today. As such, the court is going to enter a plea of not guilty for you.
I object. You cannot practice law from the bench. Violation 28 U.S.C. 454. Judge practicing law from the bench.
And put you on a trial court, on a trial calendar so that your case may be heard at trial.
I object.
All right, sir. Thank you. You'll get notice in the mail. If anything changes about your changes about your address, then you can go ahead and let us know by coming into.
I demand evidence hearing.
You will have that at the time of the trial,
evidence hearing.
You're not going to have an evidence hearing today because that's not what we're here for. This is
you are dishonorable. I got your oath, Tammi Hayward.
So, Mr. Bay, I'm going to enter a plea of not guilty on your behalf. You'll have a trial at which time you can have an evidence hearing. You'll get notice in the mail.
You're in violation of Article 6, Section 2 of the Constitution.
Your notice in the mail, then you can appear for hearing with whatever evidence that you wish to present. Although you are not required to present any evidence or testimony because the state has the burden of proving the case against you. Thank you, Mr. Brown. You're free to go at this time. All right, Kevin Jermaine Burrows.
Tiffany Woods for the people. Allison Muller here on behalf of Daniel Magoo. Mr. Magoo, can you please state your name?
Good afternoon, Daniel Magoo.
Good afternoon, Mr. Magoo. All right. We're here for an adjourned pretrial in this case.
Yes, Your Honor. After talking with Mr. Magoo, I do have a request of the court, and we had conversations with Mr. Magoo about this, but basically what's happening, I understand there was an attorney breakdown with his felony attorney from my office and him on his felony matter. So he's just recently been reassigned to Mr. Drukas. Mr. Magoo today is requesting that my office withdraw from this case, also given the same reasons, and what he thinks might be our inability to work together, and also his preference that Mr. Drukas handle all of his matters. I let him know it doesn't necessarily work like that, and unless he's, stating there's an attorney-client breakdown, then the court might not grant that. But I did want the court to know that that is his request.
Is there an attorney-client relationship breakdown or no?
Your Honor, we've only been adjourning at this point because we thought that the global resolution might be possible. I still think that's possible. I think I'm able to represent him and obtain a global if it is possible. And if at one point we learn that it's not, then I'll certainly transition into trying to resolve this matter. So from my stance, there's not an attorney-client breakdown. And I did indicate that, well, Mr. Work spoke with Mr. Magoo and indicated that. But I understand it's still Mr. Magoo's request for our office to be taken off. And so he asked that I address it to the court. And again, we've explained to him that it probably will not be granted unless he's claiming attorney-client breakdown, which I'm not sure if he is or is not.
Ms. Woods?
Judge, I'm trying to look through my notes. I don't see that anyone's requested a global offer. I'm more than happy to see if that's something we can do. I know this has been being adjourned based on his other felony cases. We did place a plea offer on the record. That was back in July. And then it's just been being adjourned to see what happens with this felony case. No one's ever come for a global or requested us to work out anything other than waiting to see what happens to the felony. Like, I guess they assumed it was going to be dismissed or not go to preliminary exam. I'm not sure.
Ms. Woods, I'm sorry if you weren't included in any emails. His attorney with my office, Alex Warren Green, was, I believe, coordinating with the prosecutor at the felony stage. And if there was a global, I hopefully would have included this, but I'll certainly reach out to you directly about the global.
I know that an argument was made on his behalf back in September 15th, along with everything that the prosecutor just said, for a bond reduction, which I granted at the request of his counsel at that time. And as you have indicated, Ms. Moeller, defendant indigent is not able to determine who their attorney is going to be. That is assigned based on the assignment office. And at this point in time, if you're saying there's not a breakdown, I'm not understanding. He doesn't get to just say that this attorney, he wants to have the same attorney. That's not how that works, Mr. Magoo. Is there something you wanted to say, sir?
It was in reference to the global resolution that I apparently the prosecuting attorney, Ms. Woods, has not received anything on. I just thought it would be, I thought having Alex and also Ms. Moeller representing me in both of my cases would have some kind of cohesive approach, but being that there was a breakdown in my felony case with the public defender's office, I just wanted to really simplify things and reduce the confusion with, obviously there's a confusion with who's messaging who on the global resolution. So I just thought it would be simpler and better for me.
Thank you. I can appreciate you thinking that, but that's not how it works, unfortunately, sir. So what I'm going to do at this time is I'm going to continue counsel as counsel is. Ms. Moeller, when we come back the next time, you should have had communications with everybody as to what's going on with the global resolution, including his new attorney. Is that Mr. Drukas?
It is, Your Honor, and that's set for this week, I believe tomorrow.
Agreed. I'll put this over to October 16th. That's Thursday, right? Yeah. October 16th, 2025 at 9:00 a.m. And hopefully we have a global resolution by then. The bond will be continued, as I said it last time. He has a 1,010% on this. I'm not sure what's going on the other matter, but he has a GPS tether if he's released on this case, which he can be.
Thank you very much, Your Honor.
You're welcome. And then on this one, I need more than 20 stickers. Wait for the chance. All right.
I'm not threatening you. Say one more word and that's 30 days. 30 days.